rise. Court of Appeals, Division 1 is now in session.
Thank you. Good morning. Please be seated. This is the time set for argument in our case number CV140431, Randall et al. Versus Maricopa et al. Each side will have 20 minutes in which to argue its position. Appellants may reserve a portion of that time for rebuttal. Counsel need to keep track of that time for yourself. We've conferenced this case. We're familiar with the issues presented. Would each of you, as you begin your argument, identify yourself and the party you represent? We are curious as to whether there are agreements as to how each side will split its time, or each side wants to devote its time to the cross appeal, etc.
Yes, Your Honor, we spoke prior to the argument and have agreed that we will go first for Maricopa County and Dr. Horn. I, Lori Vopel, will take approximately 8 minutes on the appeal, and then my colleague Eileen Gilbride will take 10 minutes on the cross appeal. I'd like to reserve a couple of minutes for rebuttal on the direct appeal. Mr. Geary, as I understand it, will be handling both arguments at the same time during his.
So we'll go 1, 2 back here and finish?
Correct. It's my understanding that there will be, the rebuttal will be limited to the appeal issue, the order granting the new trial, and not the cross-appeal statutory issue. So there's no need for me to seek to reserve time or stand up again.
Thank you, counsel. And you may proceed.
May it please the court, I'm Lori Vopel, counsel for appellant, cross-appellee, Maricopa County, and Dr. Horn. With me at counsel table is Eileen Gilbride, and she will be handling the cross-appeal in this matter. There was a lot of briefing and oral argument, obviously, on the issue of a new trial in this case, primarily because initially it started out with about 9 different areas of conduct that plaintiff's counsel had focused on. The court brought that down to 3 areas, and it's our position that based on, if you look at it as a whole, that the judge really was focused on one primary question, essentially, in a 10-day long trial, which he acknowledged took all of a couple of seconds relative to thousands and thousands of minutes. There was no answer to the question. It was just the question itself. And it's our position that if you look at the judge's struggle here, both during the motion for new trial, in the oral argument, and in his ruling on that, as well as the transcript in the motion for reconsideration, that he really is struggling with a legal question. What does Levy require me to do, if anything?
Well, but I didn't see where Judge Oberbilly ever backed off from the 3 issues that made the point of his ruling. You know, everything then focused on Dr. Posey's question, but even on the ruling on reconsideration, he goes, even if just limited, but he didn't say it was just limited.
And I agree, Your Honor, and that's why we addressed it both ways. I think that if you look at what his actual findings were, and I'm not just talking about in the post-trial oral argument, I'm talking about at trial with respect to the other 2 issues, he made specific findings. For example, on the mention of the second linear fracture, that when plaintiff's counsel reintroduced that issue in the closing argument and said, defense failed to prove their case. They didn't prove 2 linear fractures. The judge was very, very upset and ended up making findings at trial during that time that any taint that had occurred was essentially offset due to the harm that plaintiff's counsel's argument interjected into the trial by his own misconduct. And so the court found at trial that those 2 were evened out. And what I think, that at least my reading is, in going through that issue, and especially in the motion for reconsideration, the judge agreed with that and said, you're right, I did make those findings. It appears to have evened out. And in fact, he stated that he would not punish either counsel for that particular issue due to the fact that it had evened it out. So I'm focused when I'm saying that that's really not an issue anymore. Really, we were trying to go through and remind the judge how he handled that and bring that back home to him. And with respect to the question to Dr. Schwartz, the questioning, it was very awkward. There's no question about that. And that is a result of the fact that here you really had a case within a case where you have numerous treating doctors who the judge is saying they're fact witnesses, and they gave opinions that Dr. Horn, the police, and prosecutors all relied on. And so I'm going to let that come in so long as it doesn't become confused that they are also standard of care witnesses. And so there were certain limiting rulings that were given by the judge. You can't say shaken baby syndrome. You can't say what were your conclusions? Do you have a personal opinion? Do you have a conclusion in this case? But the judge allowed them to testify both regarding what their impressions were when they were treating Dylan and ultimately what they told police. They were allowed to testify to that. And the confusion during Dr. Schwartz's testimony really came about because it wasn't clear to the judge at that time. It became later once we showed him that and once he heard Detective Moran testify that what we were asking Judge Schwartz about and the actual exact question that we asked to Dr. Schwartz mirrored what Dr. Schwartz had told Detective Weber. And so what happened with that issue is, and in the motion for a new trial, plaintiff's counsel did a very good job of focusing on what happened earlier in that case. But after the evidence from the treating physicians and from the other doctors, and especially Detective Weber and Detective Moran was elicited, he said at the end, "It's just like you said, essentially, defense counsel. These doctors, these treating doctors, reported and told to the detectives, this is what I saw, classic signs of child abuse, acceleration, deceleration, injury." And what the judge ultimately said is, I'm not going, to treat this now. I'm not going to go back and try to strike that or anything, because what I've seen is that the testimony that was elicited through Dr. Schwartz, essentially, it was the same. There was no prejudice because it was the same as that which was allowed and that which the police and prosecutors relied on. So what we were just trying to do is say, Judge, you have issued two of the grounds on which you have now granted a new trial, you found at trial are not prejudicial. You found...
The problem I have with that argument, and I recognize that Levy doesn't precisely address that, but Levy suggests that when the dust settles in the heat of battle in a trial, it's time now to take another look to see what happened. And the judge, in the context of the new trial motions, took another look as to what happened, and I don't think there's any, the judge is entitled to do that. And I recognize what he tried to do to try and avoid a mistrial during the middle of the case, and he tried to avoid problems, but he took a new look, and I think Levy suggests he's entitled to do that. And he's not locked in to his initial findings in the heat of battle, in the moment of where all this is coming down in a trial setting.
That's true, Your Honor, but I also think that there's so much testimony, and that the judge, if you really read especially the oral argument on the motion for reconsideration in context, you will see him de-emphasizing those 2 points on the exact grounds that I just said. Because what the
Let's say he de-emphasized them. He certainly thought the violation of the motion in limine and the question posed to Dr. Posey, I believe is how to pronounce his name, violated Levy. He clearly thought that.
What he felt was that was significant, serious misconduct. However, it's our position that he misapplied Levy because he basically just said it doesn't matter whether it's deliberate or not, when that is the exact ground on which Levy distinguished that case from Grant. Was deliberate, intentional, purposeful misconduct. And the judge had made findings at the trial and after the trial that this wasn't deliberate, intentional misconduct. And the judge also basically eliminated the close case factor. If you take out that this is a close case and you take out that it involved deliberate, purposeful misconduct, you're left with the same type of misconduct that was involved in Grant and these other cases where the court said, the same Justice Feldman said, you can't presume prejudice. In other words, if it's significant, serious misconduct involving essential and important issues, you don't get to presume prejudice. That's what Grant says.
I thought that the trial judge here said, and I'm quoting, that the posing of the question to Dr. Posey, no pun intended there, was a direct violation of the court's motion in limine ruling and violated both the spirit and intent of the ruling. And I turn to the April 28th transcript, basically pages 51 and 52.
And, Your Honor, he did, though, make it clear at the trial and afterwards that he never did make a finding that it was deliberate. He did say it's a direct violation. And you're right, he did struggle with that. But he did not make a finding that there were numerous violations that were purposeful and intentional in a close case. He basically eliminated both of those factors and just said it's significant, it's serious, and it involves essential and important issues, which even the judge ended up conceding at the end when malicious prosecution came off the table. It was no longer an essential and important issue.
So the linchpin of your argument on this particular act of misconduct is that the court did not say, I find it deliberate.
I think the judge said at the oral argument and during trial, he did not find it deliberate. I mean, he found the exact opposite, Your Honor. And then he said he cut off the answer. He struck the question, cut off the answer, and instructed the jury. And most importantly, the judge said, I was satisfied with the way I dealt with that at trial. In fact, he denied the second request for another curative and said, I feel that we addressed that appropriately. And then the judge went through and showed how. All of the other doctors, all of the experts disagreed with Dr. Posey's opinions and that he was not a credible witness. And I think that's critical, Your Honor, because the judge said, if I didn't read Levy as telling me to ignore how I handled it at trial, I would be going a different way today. And I'd like to give the rest of the time to my co-counsel if I can. Thank you.
Thank you, counsel.
Thank you, Your Honor. Eileen Gilbride for the defense. I'm going to address the cross appeal. I'd like to try to make 4 points if I can. Point one, I'd like to be clear that we believe absolute immunity applied to this case.
Where did you argue that other than in the footnote in your answering brief? Where is the real argument?
That's where the argument is, in the
footnote?
Yes.
And you think you preserved that issue for the appeal?
Well, I think we preserved it for the appeal, but if you don't think so, we certainly...
Well, I guess You know, I read these briefs, and there's a lot of briefing here, a lot of briefing going on.
Yes.
And I thought to myself, isn't that interesting? I don't see an argument. I don't see an argument in your opening brief. In your opening brief.
In our,
Excuse me,
is
in
it
your
ans-
answer, well.
it would be our answering on cross
Yeah,
appeal.
yes, but excuse me. You raised absolute immunity on summary judgment, and you lost. You took a special action. We declined jurisdiction.
Right.
The county failed to renew the issue in a Rule 50B, but I'm not sure you had to because it was just a legal issue. So it could have been raised in the opening brief, and I did not see it raised.
In the
Then
opening-
it's buried in your brief, in your side's brief, in your brief. You could have raised it.
I have to disagree with you, Your
Okay.
Honor, because
Right.
we won at trial. We were not aggrieved by the judgment, and we only appealed from the grant of the new trial motion.
I
And
think let's-
when you appeal from the grant of a new trial motion, I don't think you can raise that in your appeal.
Okay, all right.
But either way,
Either way,
we can-
how can you say that that issue was fairly briefed in a footnote?
And that's fine if you think it was not for here. We reserve, my point is that we reserve the right to raise that if we have to go back for a new trial.
I think you should get the right to raise it back on remand if, in fact, we agree the new trial motion was proper. You had an opportunity to fully brief it, and sticking something in a footnote.
I understand, Your Honor, but there's also been an amendment to that statute which occurred after the trial, which has not been briefed below, and I think we will have an opportunity if we have to go back for a new trial. Not an issue for today. It will be, and we will raise it in trial, and we'll have to deal with it at that point. If you think it was not raised for right now, then I think we can either, A, have supplemental briefing if you want it, and if not, you can still rule, regardless of absolute immunity. We're not going to decide that today. Nevertheless, qualified immunity was correctly granted. So we can deal with it in any number of ways that's proper for here. My second point is I'd like to move on to, so the point one was that we don't want to take the position, don't want to be heard as arguing today for qualified immunity that prevents us from arguing from absolute immunity in the future.
You know,
That's
I
just,
won't beat this horse to death, but
Right.
frankly, the brief should have said that, and it did
Yes.
not say that.
yes, and I don't disagree with you, and we can still go on and talk about qualified immunity today. Second, our brief explains why immunity applies. We start with common law qualified immunity for high-level government officials. That was never done away with in stone. Ryan recognizes that. You have to let governmental officials govern. So their public duties are qualifiedly immune. When the legislature adopted the Tort Claims Act, that qualified immunity still remained. That's what Chamberlain says. Then in 2007, the legislature adopts the Uniform Anatomical Gift Act. It gives qualified immunity to people involved with organ donations, to persons, and the legislature adds subsection C to the medical examiner statute, which says medical examiners get qualified immunity for organ donations also. That's what the legislature was doing. That's it. So in adding qualified immunity for organ donations, an activity that may not be part of the medical examiner's public duties and maybe not otherwise absolutely immune in the statute or qualifiedly immune as part of his public duties, the legislature was making sure that organ donations activities get qualified immunity. That's it. That's what we have. Either we get absolute immunity from the statute or qualified immunity from the common law. This is not a case like Hutcherson. That was the case against the city for the 911 operator's conduct. In that case, the city did not argue that Chamberlain qualified immunity applied. It was a sovereign immunity case. And as Stone had abrogated sovereign immunity, the legislature enacted a comprehensive sovereign immunity statute, qualified immunity statute, and laid out the circumstances when qualified immunity would apply. That is not what we have here. We don't have a comprehensive statutory immunity, qualified immunity statute. We have the medical examiner statute, which says, okay, medical examiners, you get qualified immunity for organ donations. That is for organ donations to which the absolute immunity or the Chamberlain qualified immunity might not otherwise apply. That's all we have. Point 3, the legislature did not consider and reject immunity for all medical examiner activities. That is simply not the case. One committee of the House suggested inserting qualified immunity in a subsection D, but that suggestion never made it into any version of the Act. And the legislature, in fact, never considered it, let alone considered it and made a decision that qualified immunity shouldn't apply to medical examiner activities. The reason that proposed subsection D never made it into any version of the statute was more likely because it conflicted with the absolute immunity in 11-597. So we have no discussion about why that suggestion was withdrawn. I think it was just as easily and more likely considered that it was just rejected and withdrawn because it conflicted with the absolute immunity. And point 4 is really just a common law point, a common sense point, I'm sorry. If the legislature gives absolute immunity to all participants in autopsies, and government executives get qualified immunity for discretionary decisions, and medical examiners get qualified immunity for organ donations, then why on earth does it make sense to say the medical examiner gets no immunity for his public duties? It just doesn't. You have to kind of have a tortured reading of the statutes and the cases to get there. We'd ask you to affirm that part.
Thank you, counsel. Josh, could you add a minute to each side so we have a little bit more on rebuttal, please? Thank you.
Good morning. May it please the Court. Richard Gary and Richard Plattner, appearing on behalf of the appellees, Lisa Randall, Brenna Randall, and Tracy Allen. We have also presented a cross petition to this Court on the issue of the gross negligence standard. Please bear with me for just one moment, because in light of the argument that I've heard, I want to review, because I think it's very important to review, what are the standards that govern this Court's review of an order granting a new trial. We start first with recalling that the Supreme Court and this Court has repeatedly said that those orders are given greater deference.
Well, we understand that, but, the essence is that Maricopa County contends the trial court misconstrued Levy. And so in misconstruing Levy, if we find that, then we don't have to give such deference, because if he misconstrued the law and we don't agree with it, then we can independently, much like a motion for summary judgment, look at the facts to see if in fact they meld, and if they don't, then we can say he was wrong and send it back to have the verdict entered.
Well, therein lies the rub, Your Honor, that word of what it is that Judge Overbillig allegedly misapplied. And where you have to look to answer that question is his order, his final written order and what it says. Now, I'm not excluding the transcript, but to address the question that was raised by Judge Norris, this Court and the Supreme Court has answered that explicitly. In the Liberatory decision, this Court stated that a judge's initial determination as to the prejudicial effect of the misconduct at trial is neither binding nor given priority. In the Sanchez decision, the Arizona Supreme Court clearly stated that while the judge sustained objections and the party timely made those objections. In Sanchez, the Supreme Court said unequivocally that does not bind the trial judge at the end of the day from determining that his remedies sustaining the objections was not sufficient. But let's return to that order, Judge Portley, because that's where the judge's final determinations were at the end of the day. And that order proceeds with this statement. The new trial.
Are you talking about the reconsideration or the new trial determination?
I am talking about the only order, Your Honor, and that's the order that was issued as a result of the new trial, not the shorthand that Judge Oberbillig used in denying the request for reconsideration, which does not, on its face, modify, delete, alter, or change anything from the order that's required pursuant to Rule 59. And that's where his order starts.
And what's the record cite?
Pardon me?
What's the record cite of what you're going to tell us?
The new trial order
Right.
itself.
Right.
It begins with pursuant to Rule
No,
59.
but where is it in the record? I just wanted to pull it up.
Oh, it's the transcript of the proceedings.
You want the transcript? I thought it was in the order.
Well, actually, it's both, because ultimately, the new trial order that Judge Overbillig signed is near verbatim
I thought.
what he read from the bench at the hearing on April 28th. But the new trial order, pursuant to the rule, says that the new trial is being ordered pursuant to Rule 59. He then sets forth the legal criteria that's not only in Rule 59, but he goes on to cite the Levy criteria, which, please note, says that he needs to consider the issue of whether it's a closed case. Now, the middle is the factual support for his order, and then drop down to the conclusion where he says, I find prejudice. He didn't presume it. He didn't infer it. He found, I find prejudice. And then he went on to state that the criterion in Levy has been met. What criteria? The criteria that appears at the start of the order. And again, let me go back to the Liberatore decision, where this court said that a new trial order will not be read in isolation or without reference to the record, and the judge does not need to make a lengthy exposition of the facts. Let me touch on just briefly some of the issues raised by the defendant. The notion that Judge Oberbillig felt that this was not a close case. Please allow me to read his words. Quote, this is a difficult case. You guys did such a great job of giving us a lot to think about on both sides. There is so much evidence that could be interpreted different ways that could affect the outcome. When I see a battle where every issue is contested, where every lawyer has a punch and a counter punch and does it well, and that's what I saw in this case. That's what anyone will see reading the record. Now, he used the phrase hotly contested. The record, which Liberatore says must be reviewed in support because of the deference given in order affirming a new trial, clearly demonstrates his attitude on whether this was a close case. He cites it in the beginning. He makes it a part of the criteria. He says that criteria has been met. But even more important, let's go to the argument, if we're going to look at the argument on the motion for reconsideration, where he twice acknowledges that the close case issue is part of the criteria. And in there, and I'll start with at page 34, he goes, I agree. I'm looking for whether it's prejudicial, and the extent is impossible to determine in a close case. But even more important, now at page 52, I think it would be best if we stay focused on their reference to the standard. I only have to find that the misconduct is significant, and it goes to, important issues. And the extent is impossible to determine the prejudice. That is, in a close case. The exchange that then occurs with defense counsel is very interesting. Later, and this appears at page 57, again, Judge Overbilling states what the law requires at a minimum, and that is misconduct that is prejudicial
It involves essential and important issues. And he says, I don't think we're missing any element. Defense counsel interrupts and says, but Judge, the extent of the prejudice, it cannot be determined because it's in a close case. Judge's answer, right. And we can't determine that here. That's page 57, line 18, going on to page 58. So the notion that he did not consider that legal criteria is wrong, clearly by the record, clearly by the written order. The notion that he didn't consider it a close case on the evidence is clearly wrong. Now, let me be clear. And while this court has been blissfully somewhat quiet up to this point, Judge Overbillig's oral argument is a rigorous exercise of role-playing, sarcasm. I want to stop there because I wanted to say very clearly that I am very complimentary on how he does it. But it's an exercise, and you bet. Can the defendants point to comments that he made in the course of the oral arguments that were not flattering to our case? Absolutely. Can we, and did we in the brief, point to equally number of statements made in the oral argument not flattering to the defendant's case? You bet. But that was the analytical process that the judge used. Not the final determination, not the final factual determinations. That's found in the order. Let's go to this notion of...
So essentially what you're saying, we've got to give deference to his determination, because if we're reading just the words, we may not understand the nature of the oral argument other than whatever the words may say on the document.
Forgive me, Your Honor, and I resist whether I would do this, but did you see the movie My Cousin Vinny? Do you remember the scene? I shot the sheriff. You shot the sheriff. I shot the sheriff. Now go ahead and read that on the transcript. It was done at the trial, and I can't tell you because it would be improper for me to do that.
Well, we know you shot the sheriff, but that's okay.
But that is why the Supreme Court and this court have repeatedly said the reason we do not interfere with the factual determinations is because you are left with simply a cold record that cannot reflect what was occurring. On the issue of whether it was knowing and deliberate, read Levy. Levy does not state significant misconduct only if it's knowing and deliberate. Levy says especially if. And why? Because Levy was a lecture to all of us, to attorneys as officers of the court, to the appellate court on the role that the instructions and curative instructions play in the prejudicial analysis, and most of all to the trial judges to cut it out. When you are faced with significant misconduct that prejudices the essential issues of a case, and you can't determine the extent of that prejudicial misconduct, whether it's a close question of the prejudice on the case itself, you better find prejudice. You better infer that. You better give the benefit of the doubt. Because otherwise, what's going to happen? We're going to find that you abused your discretion. And doesn't that make sense? How does a trial judge, in the face of knowing and deliberate significant misconduct, the extent of which is impossible to determine, deny a new trial? Because Rule 59 in the Grant decision, which is the rule that the Supreme Court in Levy explicitly says, we adopt that rule for this situation. That's the rule that existed prior to Grant. It's the cases noted in Levy. It's the rule that Levy adopts for this situation. And that is when the misconduct is significant that affects the essential rights of a plaintiff and denies them a fair trial, a new trial is warranted. To say that that is only warranted in the face of knowing and deliberate conduct is an absurdity. To say that a new trial, that a judge abuses his discretion because he orders a new trial, in the face of knowing and deliberate conduct, but the evidence isn't 50-50, think about what standard you create for the trials that are going to be conducted in the interests of justice that just went out the door.
Well, they seemed, the Supreme Court and Levy seemed to talk about professionalism as they're recounting the rule, and clearly those facts in that case were different than the facts that we have in this case. And so it then, the court looked at those facts and said, we've got to stop this. But here we had a trial court who was actively engaged in all parts of the discussion, but has come down where he did.
Respectfully, Your Honor, you're wrong on 2 counts.
Okay.
First, the factual situation that occurred in Levy is actually less than what occurred in this case. Let me be specific. In Levy, the Supreme Court noted and the trial judge noted that they used an expert witness to bolster the credibility of a lay witness. The only other distinction was made was not factual, but it was an interpretation of the conduct where the court in Levy said in this case the conduct was knowing and deliberate. In Grant, it was not. But those factual distinctions, when you look at what the judge found in this case, you found a deliberate violation, according to the judge, of a motion in limine where he told counsel verbally on the record, don't bring in what the judge did below, where they had the cases that from this court already in advance before the limine ruling of how highly prejudicial it is to suggest to a jury that a judge has disregarded or has rejected the opinion of one party, the Crackle decision, Your Honor. Mm-hmm. And in the face of re-arguing that at the limine ruling, they go and ask the very thing that he said not to do, and he was floored and shocked. And he said, if we want to go to the trial, how do you unring that bell? I doubt you can unring that bell, that prejudicial bell. How strong a statement to tell the jury that a judge disregards. With reference to the hospital doctor, I don't need to lecture this panel about why there is one independent expert and one expert, the defendant, on the standard of care and the unfairness of piling on. And even if I did, Judge Overbilling made it very clear. He made it clear pre-trial, what to do, how to do it. There's only going to be one expert. And it wasn't just one question with Dr. Schwartz. Look at the record. It started with the opening statement. The defendant said the hospital doctors were on board with the defendant. Then with the prosecutor, repeated questions, repeated objections, repeated sustained, repeated discussions, stop it. Repeated questions with the prosecutor that the hospital's doctor's conclusions did not differ with the defendant. Then let's go on to the hospital doctor. I'm going to call him a lay witness, although they used him in the capacity, but he wasn't an experienced witness. And the questions were so intended that even he got it on the witness stand and said, well, you're asking me my personal opinion. And he looks up at Judge Overbilling and says, I thought I was under restrictions in front of the jury. And then with the police report, let's go to the police report and that question about throwing in classic signs of child abuse right after the judge said, don't do it. Because in the second argument, the reconsideration argument, he explicitly states with reference to that question, I've called it misconduct and I'm not backing off from that. Now, on the issue of whether it was knowing and deliberate, I need to take exception with the argument presented to you. So let's be very specific. Judge Overbilling did not make that finding, one way or the other. He didn't feel he needed to because in accordance with the law, Rule 59, Grant and Levy, it was not required. Motion for new trial is not dependent upon whether misconduct is knowing and deliberate. A judge does not abuse his discretion in granting a new trial in the absence of knowing and deliberate conduct, but he sure abuses his discretion by denying a new trial in the face of knowing and deliberate conduct. And that's the lesson of Levy. That's why Levy was distinguished from Grant. But the judge was very clear, and he put his comment on the record. You're too good a lawyer for this to be inadvertent. The three most essential issues in the case, and that's where the slip-up occurs, and I'm supposed to believe that's inadvertent? That question certainly sounds like it was crafted deliberately to try and evade my motion in limine ruling. Now again, so I'm not misconstrued here. He didn't make that finding, but if you want to look what he was thinking, look there. But he certainly did not make a finding that this conduct was not knowing and deliberate. Unless there's, Judge Portley, I'm going to be the trial lawyer and read your face. Is there a question you have?
Not right now, no.
Okay. Unless there's further questions on this issue, I would like to go and move on to touch on the cross appeal issue. And first, let me say, if the issue of absolute immunity was raised in this brief, it's a surprise to me, because I didn't believe that stuffing something in a footnote and a parenthetical reference to what a legislature did in 2014 is the way that you raise an issue on appeal. That said, this court and the Supreme Court have been very clear. And allow me, please, because I can't put it better than the Supreme Court did.
We'll quote you on that.
Please, not for all time.
Okay.
Oh no. Oh, no. Even if we get further reflection in the quiet moment, as Learned Hand would say, you know.
Okay, done. Thank you. We have consistently recognized the power of the legislature to retain or confer immunity where appropriate. When allegations fall directly within the language of the statute, the specific statutory grant of partial immunity controls the degree of immunity afforded the defendants. Our Constitution instructs, in this instance, the decision is for the legislature, not the courts. We recognize nothing more than the expressed authority the Arizona Constitution confers upon the legislature to define those instances in which public entities and employees are entitled to immunity. The legislative enactment of a specific statutory provision that applies to the actions and entities involved here also serves to distinguish those situations where we considered in other cases we applied common law immunity principles in the absence of statutory guidance. Here are the undisputed facts. The plaintiff's allegations fall directly within 12594A, the negligent determination of the cause and manner of death. Neither side argued the statute is ambiguous in any fashion. This court and the Supreme Court has said the analysis starts with the statute, and if the statute is unambiguous and the gross negligence standard is not expressly set forth, we cannot rewrite or imply terms that aren't there. We don't need to go to the legislative history, but the committee's decision to withdraw qualified immunity for all of the conduct is appropriately and accurately stated in our brief. They considered it and they rejected it. We should not have been put to the burden of the gross negligence standard. Thank you.
Thank you, counsel.
Just a few quick points. First of all, as far as the language of what the judge actually found versus what's in the transcripts, if you look at the motion for new trial order, plaintiff's counsel drafted that. They took the language directly from the transcript, from the oral argument on the motion for new trial after the parties went back and forth, back and forth, back and forth on what the judge's findings were. So instead of drafting his own, they just took it directly and the judge signed it from the transcript. So what is in the transcript is important.
Having looked at the order, the judge discusses the deliberate nature that as an element, although I didn't particularly find the close call issue that helpful, but he used hotly contested, which seems to me to be pretty close to close call. But then he finds that the requirements in Levy were met. It's the very last sentence or two of his order.
But if you look at his actual findings in this order, they do not address whether it's a closed case, nor do they address that it's
But aren't
deliberate
we really
misconduct, Your
trying
Honor.
to impose a requirement of specificity that Levy doesn't require? I mean, if the judge says, I find all of the requirements of Levy have been satisfied, isn't that adequate?
Not when he, subsequent to that, is struggling on whether he is actually applying Levy correctly, Your Honor. And there's no question from this transcript that he was. And if you look at the final order, which is also an order, and the only order that he actually wrote himself, the Levy-Parcell criteria uses ellipses, where especially knowing and deliberate and where close case criteria are go, after which the judge specifically said this court finds defense counsel's misconduct was significant and involved important and essential issues, even if just limited to the Posey question, and apparently successful in achieving its goals. So his actual findings and the ones he actually wrote out leave out those two criteria, and specifically stated at the new trial hearing. That's what I'm doing when I look at Levy and I say, does Levy really apply here? If I haven't made a finding of knowing and deliberate, because to me that's intertwined with what Levy's saying here, then the presumption of prejudice doesn't apply, and you're put to the task of demonstrating actual prejudice, which I've never found you've done to this point. This case, his orders all came down to whether this presumption of prejudice applies, and he misapplied the criteria and wrongly presumed prejudice in a case that he went through and detailed why the evidence was not close at all, but was overwhelmingly in the defense favor. And this wasn't a med malpractice case, so the judge said that the one rule, expert rule, doesn't really apply. He was just trying to have the evidence come out in a way that would be appropriate. Thank you.
Thank you, counsel, for your arguments. We'll take the matter under advisement. We'll issue our decision in due course. We'll be at recess.